I stopped the trial once. Not postponed it. Not recessed it. Stopped it. And I've been a district court judge for 19 years. You don't do that unless something is very, very wrong. The case was supposed to be simple. A civil matter. Family dispute over an estate. The deceased was a woman named Margaret Holloway, 73, survived by 3 adult children and 1 granddaughter. The granddaughter was the plaintiff. Her name was Sarah, 26 years old. She sat alone at the plaintiff's table with a public defender who looked like he'd rather be anywhere else. Across the aisle sat her entire family. Her mother, her uncle, her aunt, and 2 cousins. They had 3 attorneys. Expensive ones. The kind that bill by the breath. I noticed Sarah before proceedings even began. She didn't look at them. Not once. She kept her eyes on the table in front of her, hands folded, back straight. There was something about the way she held herself, like she learned a long time ago that the world wasn't going to be kind, so she stopped expecting it to be. Her family, on the other hand, was loud, confident. They whispered among themselves, laughed quietly at jokes I couldn't hear. One of the cousins, a man in his early 30s, pointed at Sarah and smirked. Her mother rolled her eyes. I don't tell these stories often, but if you stay with me, you'll understand why this one still keeps me up at night. The estate in question was valued at just over $400,000. Not a fortune, but enough to fight over. Margaret Holloway had left a will. In it, she divided her assets evenly among her 3 children. Standard, reasonable, except Sarah claimed there was a second document, a handwritten amendment. In it, Margaret allegedly left Sarah $50,000 and a small property in Vermont, a cabin. The family's attorneys argued the document was a forgery, that Sarah, desperate and estranged from the family, had fabricated it after her grandmother's death. They had testimony lined up, character witnesses, financial records showing Sarah had been struggling. They painted a picture of a young woman so broke, so morally compromised, that she'd stooped to fraud. Sarah's attorney had almost nothing. A copy of the handwritten document. A photocopy, not even the original. No witnesses. No corroboration. It didn't look good. I asked Sarah's attorney where the original document was. He hesitated. Then he said Sarah had stored it in her apartment, and the apartment had been broken into 3 months prior. The document was taken, along with some jewelry and a laptop. The defense attorneys practically laughed. One of them, a man named Kirkland, stood up and said, "Your Honor, this is beyond absurd. A convenient burglary. No police report. No evidence the document ever existed. We're wasting the court's time." I asked Sarah's attorney if a police report had been filed. He said yes. He submitted it into evidence. I read it. The report was real, filed with the local precinct, but it was bare bones. No suspects, no recovery. It proved a burglary happened, but it didn't prove what was taken. Kirkland dismissed it with a wave. He said anyone could file a police report and claim anything was stolen. I didn't like him, but he wasn't wrong. Still, something about the whole thing felt off. I've been doing this long enough to know when someone's lying, and I've been doing it long enough to know when someone's telling the truth but can't prove it. Sarah looked like the latter. I asked her to stand. She did, slowly. Her hands were shaking. I asked her directly, "Miss Holloway, did you forge this document?" She looked me in the eye. Her voice was quiet, but it didn't waver. "No, Your Honor. My grandmother wrote it. She gave it to me 2 weeks before she died." I asked her why. She said her grandmother wanted to make sure she had something, that the rest of the family had already gotten plenty over the years, but Sarah had been on her own since she was 16. Her grandmother knew she was struggling. She wanted to help. Her mother, seated behind the defense table, laughed, out loud, in my courtroom. I looked at her. She didn't stop. She leaned over to her brother and whispered something. He laughed too. I warned them. I said, "This is a courtroom, not a theater. You will conduct yourselves appropriately, or you will be removed." The mother looked at me like I just told a joke. Then she said, "I'm sorry, Your Honor. It's just hard to take this seriously when she's been lying her whole life." I told her she was not to speak unless called to stand. She smiled, nodded, sat back, but the damage was done. Sarah's face had gone pale. She sat down, staring at her hands again. I called a 15-minute recess. I needed to think. In my chambers, I reviewed the file again. The photocopy of the alleged amendment was in Margaret's handwriting, or at least it appeared to be. The defense had their own handwriting expert who would testify it was a forgery. Sarah couldn't afford one, but there was something else in the file. Something I almost missed. A letter, typed, signed by Margaret's primary care physician. It was dated 3 years prior. In it, the physician noted that Margaret had expressed concerns about her family's treatment of Sarah, that Margaret had specifically asked about the legality of amending her will without informing her children. The physician had advised her to speak to an attorney. I didn't know if Margaret ever did. The letter wasn't proof of anything, but it suggested Margaret had been thinking about this, that Sarah's claim wasn't coming out of nowhere. I returned to the courtroom. Kirkland called his first witness, Sarah's mother, Patricia Holloway. She took the stand with the kind of confidence that only comes from knowing you've already won. Kirkland asked her to describe her relationship with Sarah. She sighed, like the question pained her. She said, "Sarah has always been difficult, even as a child. She was defiant, ungrateful. We tried to help her, but she pushed us away." I watched Sarah. She didn't react. Kirkland asked Patricia when she last saw her mother alive. Patricia said she visited Margaret every week, sometimes twice a week. She took care of her, made sure she had groceries, medication, company. Kirkland asked if Margaret ever mentioned wanting to leave anything to Sarah. Patricia laughed again, softer this time, but still cruel. She said, "My mother barely spoke about Sarah. She was heartbroken that Sarah had cut us all off. She used to cry about it." I looked at Sarah. Still no reaction. Kirkland asked if Margaret had ever mentioned writing an amendment to her will. Patricia said absolutely not, that her mother had been very clear about wanting to divide everything equally among her children, that she'd said so many times. Kirkland thanked her, sat down. Sarah's attorney stood to cross-examine. He was young, nervous. He asked Patricia if she was aware that Sarah had been living in her car for 6 months during college. Patricia blinked. She said she wasn't aware of that. He asked if she knew Sarah had dropped out of college because she couldn't afford it. Patricia said Sarah made her own choices. He asked if Patricia had ever offered to help. Patricia said Sarah never asked. He asked if Sarah had been invited to family gatherings. Patricia hesitated. Then she said she wouldn't have come anyway. He asked if she'd ever been invited. Patricia didn't answer. The attorney pressed, "Mrs. Holloway, yes or no? Was Sarah invited to family gatherings in the last 10 years?" Patricia's face hardened. She said, "No." The courtroom was silent. He asked why not. She said, "Because she made it clear she wanted nothing to do with us." He asked when Sarah made that clear. Patricia said, when she was 16. She left. She ran away. He asked if Patricia knew why. Patricia said, because she was a troubled teenager. He asked if Patricia had ever asked Sarah why she left. Patricia said no. He sat down. I had more questions. I asked Patricia if she reported Sarah as a runaway when she left at 16. She said no. I asked why not. She said she was almost an adult. We figured she'd come back when she was ready. I asked if she ever tried to find her. She said no. I asked if she'd contacted Sarah when Margaret became ill. She said no. I asked if she contacted Sarah when Margaret died. She said we didn't have her information. I asked if she tried to get it. She said, "No, Your Honor, I dismissed her." The next witness was a handwriting expert. He testified that the amendment was a forgery, that the slant was inconsistent, the pressure uneven, that it had been written by someone attempting to mimic Margaret's handwriting. Sarah's attorney had no expert to counter him. It was looking bad. Then Kirkland called his final witness, Sarah's uncle, Margaret's son. His name was Dennis. He was calm, polished. He testified that Margaret had been a sound mind up until the very end, that she'd never mentioned Sarah, that the will had been finalized years ago and never questioned. Sarah's attorney asked him the same questions he'd asked Patricia. When had he last seen Sarah? Had he tried to contact her? Dennis said he hadn't seen her since she was 16, that it wasn't his responsibility to chase after her. Then Sarah's attorney asked something I didn't expect. He asked Dennis if he was aware that Sarah had been hospitalized at age 15. Dennis froze. He said he wasn't. The attorney asked if he was aware of why. Kirkland objected. Relevance. I sustained it, but I saw something in Dennis's face. Just for a second. Fear. The attorney sat down. I called another recess. In my chambers, I pulled Sarah's file again. There was nothing about a hospitalization, but now I was curious. I made a call to an old colleague in family court. I asked if there were any records on Sarah Holloway. There were. What I found made me feel sick. When I returned to the courtroom, I didn't sit down right away. I stood there, looking at the family seated behind the defense table, looking at Patricia, at Dennis, at the cousins who'd been smirking and whispering all morning. They looked back at me with that same confidence, that same certainty that they'd already won. Sarah sat alone, still staring at her hands. I sat down. I asked both attorneys to approach the bench. They did. I told them I'd made some calls during the recess, that I'd obtained records from family court, that those records were sealed, but given the nature of this case and the testimony I'd just heard, I was entering them into evidence. Kirkland's face went white. Sarah's attorney looked confused. I told them what I'd found. When Sarah was 15 years old, she'd been admitted to the hospital with a broken arm, 3 fractured ribs, and a concussion. The attending physician had noted bruising consistent with repeated physical abuse. A social worker had been called. An investigation was opened. Sarah had been removed from her mother's home and placed with her grandmother, Margaret Holloway, on an emergency basis. The case had been settled quietly. No charges filed. The family had agreed to a safety plan. Sarah would live with Margaret. Patricia would complete parenting classes. The matter was sealed. Sarah had lived with her grandmother for 8 months. Then, according to the records, Margaret became ill. She couldn't care for Sarah anymore. The family claimed they'd made arrangements for Sarah to return home. But Sarah had run away 2 days before the planned return. She'd been 16. She hadn't run away because she was troubled. She'd run away because she was terrified. Kirkland tried to speak. I cut him off. I told him I was calling a witness. Sarah's grandmother's physician, the one who'd written the letter in the file. He was retired now, but he'd agreed to come in. He was waiting outside. Kirkland objected, said this was beyond the scope of the original case, that we were here to determine the validity of a document, not to retry a decades-old family court matter. I overruled him. The physician was an older man, 70, maybe 75. He took the stand and was sworn in. I asked him to describe his relationship with Margaret Holloway. He said he'd been her primary care physician for over 20 years, that he'd known her well. I asked him if Margaret had ever discussed her family with him. He said yes, many times. I asked him what she'd said. He looked at Sarah, then back at me. He said Margaret had been heartbroken over what happened to Sarah, that she blamed herself for not intervening sooner, that she tried to get custody of Sarah permanently, but the family had fought her. They'd claimed Margaret was too old, too sick, that they'd promised Sarah would be safe. He said Margaret never forgave herself for believing them. I asked him if Margaret had mentioned wanting to leave Sarah anything. He said yes, that Margaret had talked about it often in her final years, that she wanted to make sure Sarah was taken care of, that she felt the rest of the family had taken enough from her already. I asked him what he meant by that. He said Margaret had loaned her children money over the years, tens of thousands of dollars, Patricia's mortgage, Dennis's business, the cousin's college tuition. None of it had been paid back. Margaret had never asked for it, but she'd kept records. I asked if he knew whether Margaret had written an amendment to her will. He said she'd told him she had. About 3 months before she died, she'd shown it to him. He'd witnessed her sign it. The courtroom went silent. Kirkland stood up. He said the physician couldn't possibly verify the handwriting, that his testimony was hearsay. I told him to sit down. I asked the physician if he remembered what the amendment said. He said yes, That Margaret had left Sarah $50,000 and the cabin in Vermont, that she'd said Sarah deserved a place to feel safe. I asked if he still had a copy. He said no, but he remembered it clearly. I thanked him, dismissed him. Then I did something I've only done twice in my career. I called Sarah to the stand. She looked terrified. Her attorney started to object, then stopped. He knew better. Sarah walked to the stand. She was shaking so badly, she could barely raise her right hand to be sworn in. I asked her to sit. She did. I asked her why she didn't tell anyone about the abuse. She said she was afraid no one would believe her, that her family would say she was lying, that they'd done it before. I asked her what she meant. She said when she was younger, she'd tried to tell a teacher. The teacher had called her mother. Her mother had cried, said Sarah was acting out for attention, said she was going through a phase. The teacher believed her. Sarah never tried again. I asked her what happened the night she went to the hospital. She said her mother had pushed her down the stairs, that her stepfather had been drunk, that her mother had told the doctors Sarah had fallen. I asked her why she went back to her grandmother. She said the social worker gave her a choice. Go to her grandmother or go to foster care. She chose her grandmother. I asked her why she ran away. Her voice broke. She said, because my grandmother got sick, and they said I had to go back. And I knew if I went back, I'd die. The courtroom was completely silent now. I asked her where she went. She said she lived in shelters, then with friends, then in her car. She worked under the table, saved everything, eventually got her GED, tried college but couldn't afford it. She'd been working 2 jobs for the last 8 years just to stay afloat. I asked her when she last saw her grandmother. She said 2 weeks before she died, that she'd found out Margaret was in hospice, that she'd gone to see her, even though she was afraid her family would be there. I asked her if they were. She said no. It was just Margaret, alone. I asked her what they talked about. Sarah started crying. She said her grandmother had apologized over and over, said she should have fought harder, should have protected her. Sarah told her it wasn't her fault. Margaret had pulled out the amendment. She'd already written it. She gave it to Sarah and told her to keep it safe, told her she deserved something good, told her the cabin was hers. That was the one place Margaret had always felt safe, and she wanted Sarah to have that. Sarah had taken it. She'd kept it in a folder with her other important documents, birth certificate, social security card. Then her apartment was broken into. I asked her if she knew who did it. She said no, but the only things taken were that folder, a laptop, and her grandmother's jewelry. Everything she had that was valuable or important. Nothing else. I asked her if she suspected anyone. She didn't answer. I asked again. She said quietly, my cousin knew where I lived. He'd shown up a few weeks before. Said he wanted to reconnect. I didn't let him in, but he saw my apartment number. I looked at the cousin, the one who'd been smirking earlier. He wasn't smirking anymore. I asked Sarah why she didn't mention this before. She said she had no proof, that she knew how it would sound, that she was used to not being believed. I dismissed her. I sat there for a long moment, looking at the family, looking at Sarah. Then I made my decision. I said, this trial is over. Kirkland stood up. He said, Your Honor, we haven't even presented our closing arguments. I said, you won't need to. I said I was ruling in favor of the plaintiff, that based on the testimony of Margaret's physician, the sealed family court records, and the credible testimony of Sarah Holloway, I found that the amendment was valid, that Margaret Holloway had intended to leave Sarah $50,000 and the Vermont property, that the estate will be divided accordingly. Kirkland objected, said I couldn't rule based on testimony about a document that no longer existed. I said I could, and I was. He said he'd appeal. I said he was welcome to try. Patricia stood up. She screamed at me, said I had no right, that Sarah was a liar, that she'd poison her own mother against them. I told her to sit down. She didn't. I held her in contempt, fined her $1,000. Told her she said another word, I'd have her removed in handcuffs. She sat down. Dennis looked like he wanted to say something. He didn't. The cousin stared at the floor. I dismissed the court. Sarah sat there, crying, Her attorney put a hand on her shoulder. She didn't move. The family left. They didn't look at her. I went back to my chambers. I sat there for an hour, just thinking. I'd bent the rules, maybe even broken them. An appeal was almost certain. I might even be reprimanded. But I didn't care, because I knew what had happened. I knew that family had abused that girl, had driven her away, had tried to erase her. And when Margaret had tried to make it right, they'd stolen the one thing that could prove it. I couldn't prove the cousin had broken into her apartment. But I knew, and I knew that if I didn't stop that trial, if I let them win, Sarah would have walked out of that courtroom with nothing. Again, I couldn't let that happen. A few weeks later, I got a letter, handwritten, from Sarah. She thanked me, said she'd gotten the money, that she'd gone to see the cabin, that it was small and needed work, but it was hers, that for the first time in her life, she had a place that felt safe. She said she didn't know if I'd bent the rules for her, but if I had, she wanted me to know it mattered. I kept that letter. I still have it. The family did appeal. The appellate court upheld my decision. They cited the physician's testimony and the preponderance of evidence standard in civil cases. I wasn't reprimanded. But even if I had been, I'd do it again. Because here's what I learned that day. The law is supposed to be impartial, objective, fair. But sometimes, fairness isn't about following every rule. It's about recognizing when the system has already failed someone. When the scales are so unbalanced that the only way to make things right is to use whatever power you have to tip them back. Sarah had been failed her entire life. By her family. By the system. By everyone who should have protected her. I wasn't going to fail her too. So I stopped the trial. And I'd do it again. I think about that case sometimes. About whether I did the right thing. Whether I overstepped. But then I think about Sarah. About the fact that she has a home now. A place that's hers. And I know I did. If you've ever been in a courtroom, or if you've ever felt like the system wasn't built for people like you, I want to ask you something. Do you think justice is about following the rules, or is it about doing what's right, even when the rules don't cover it? Leave me your answer below. I'd like to know. And if this story meant something to you, if you know someone who believes the system should protect the vulnerable, not just the powerful, share it with them. I don't tell these stories to feel good about myself. I tell them because someone needs to remember that behind every case, there's a person. And sometimes that person just needs one voice to say, I believe you. I was that voice for Sarah. I just wish she'd had it sooner.